remains in session. You may be seated.
Okay. Our next case this morning, Moore versus Wagner.
Good morning, Your Honors. May it please the court. My name is Brandon Vestland from the Florida appellate firm. I'm here on behalf of the appellants, Dr. Sean Moore and Mrs. Kira Moore. I'd like to reserve 5 minutes for rebuttal.
Very good.
Your Honors, briefly, I'll go over the facts with you. August 2019, this family, the appellants were relocating to the Tampa Bay area and their children were about to start school. Dr. Moore came in advance of the family and he and his real estate agent, Mrs. Pitcher, saw a house in Lutz that was owned by Mr. Wagner as the trustee of trust number 18605. He had about 20 to 25, 35 minutes to review the house before he had to go to the airport, catch a plane. House looked fine. He didn't even look in the garage because apparently the garage had been converted. He thought he had
Right, there's a theater, home theater.
Yeah, so he basically, the house looked fine. They were in a hurry. He said, okay, fine, I'll do the deal. Give me the contract, all this, what he
We
was
signed a
presenting.
document that
Present.
required him to pay a bunch of money for background check.
Correct. It's the lease application.
Right.
And the lease application is in the record numerous places, but I'm going to refer to pages 349 and 350. I had blown them up, but apparently didn't get permission.
Yeah.
Sure.
In front of us.
Sure.
So,
So I just want to go over a couple things in the lease application. Because it's interesting that they're using this as a contract. The lease application doesn't identify the house, doesn't identify the landlord, doesn't identify the amount of the rent, does not identify.
But that would be required, those are essential terms for a lease.
That's correct, Your Honor.
One of the receiving this case that I've been considering and reading all the materials is that there's a conflation in your argument of the lease and the application agreement. The application agreement is a standalone agreement with mutual obligations, right? You take it, it's just to reserve a property for rental.
Your Honor, it's a document that has a condition precedent in it. If you look at the second line towards the bottom, it says, if applicant and any co-applicants are approved and applicant and any co-applicants refuse to enter into the proposed lease,
right.
the terms of the proposed lease is the condition preceding. They have to present the lease. So
That's another interesting aspect. That was, it's characterized for you as a material fact. But it's only material because arguably, and I'll just propose another way of looking at it for the sake of discussion. It's only material whether what's actually you're presenting as a material fact is material, not whether they presented the lease, but whether they presented the lease before your client decided that they didn't want to sign the lease anymore. In other words, there's nothing that says they had to send it. They had to present it on the 13th, the 12th, the 14th, the 16th. On the 15th, your client said, you know what, we haven't gotten it yet. We're not going to sign it.
Your Honor, there's two issues. The first issue we were talking about a minute ago is that whether this is a contract, okay? And it has.
Well, I mean, it seems pretty clear that, you signed that agreement.
Your Honor,
So the question is, to me, the question is, he never got a lease.
that's
So you can't refuse to enter into a lease if he's never been presented with a lease. I mean, that to me seems more
our second argument.
like the argument that,
Well, simply have two major questions of material fact. Number one, did he get a lease?
right,
Number two, did he anticipatorily breach the lease?
Your Honor, then.
Go to the
Okay, well, let's go to the second argument of my brief, and that is whether there was, material facts in dispute, and that is about whether or not he ever received the lease. And their response brief raised anticipatory repudiation for the first time since their initial affirmative
But you don't
defense.
have to characterize it as anticipatory repudiation.
Well, that's what you characterize it.
I'm trying to characterize it a different way. You don't have to buy it, you may not, but it's not necessarily about anticipatory repudiation. But what the appellants did was they artificially created a deadline that was not a part of the agreement. which is up until X time that we decide we waited long enough, you have that amount of time to present us a lease. What could have happened is this, is, okay, we really want to live here, like we said we were gonna do, and let's get that lease. You know, in other words, it all seems a bit artificial to me, that, you know, this, I'm thinking of the relevant dates, and maybe I get them wrong, but I think it was the 16th they entered into the Tampa Palms lease, and then on the 15th was when I won't use repudiation, when they said, you know what, that's it. We don't want to sign a lease anymore because we don't have it yet. And then, you know, what happened on the 14th, what happened on the 13th? Why didn't they just live in the house they had agreed to live in? Why not? Why didn't they just say, you know, come on, get the lease, bring us the lease? Why announce that we're now, that the time, your time is up, landlord?
Well, there's two things there. First of all, you don't move into a house until you have the terms of what the landlord could have, in his mind, I'm living in the basement, like in Ozark, you know, I'm gonna live in the basement, or maybe he's gonna decide he can go in there anytime he wants to, or maybe he's gonna decide that it's $1 million.
The lease would include all those.
But you don't move into a house until you have.
So explain to me that, you know, establish that there was an obligation by the 15th.
The obligation.
Why was there an obligation by what's significant about that day? Because that's the day that the appellants decided that they no longer had the obligation to enter into a lease.
Mr. Wagner told my client, his testimony is, and the testimony of Ms. Pitcher, who's the real estate agent, was he said he's never provided a lease, he doesn't have to. So there's that, and that factor is going to come in at trial. If we get back to trial, we'll be able to present, you know, there might be an anticipatory repudiation on his part. But the bottom line was he asked for a lease. Mr. Wagner knew that they were in a jam. He wrote ASAP on this lease application. None of the terms are defined in here. It says he wants a lease. You're talking about.
I hadn't signed it anyway, and he signed this application deposit agreement that says if you're approved, you got to enter into this lease, and he hasn't seen the lease. So it doesn't matter whether the lease says you get to live in the basement, because he's agreed to enter into this lease if he's approved or forfeit this deposit.
Well, Your Honor, that's why we argued that it's an illusory contract. If there's no terms of the lease in front of him, the lease could be for a doghouse in the backyard. We don't have any. Your Honor, that's like somebody saying, you know, I'll build your house for $1 million. And you say, great, let's do it. And then they build a tiny house that's worth $10,000.
Maybe he shouldn't have signed this.
Well, Your Honor, hindsight's 20/20. He was told at the time, and his testimony is that the man said, "I'll give you your money back, no problem."
So
It doesn't work out.
let me characterize this a different way. So you're raising, and you do in your briefs cogently, some downside for the prospective tenants, that precipitated by this sort of Spartan agreement without much detail. So isn't there a corresponding downside to the landlord that actually has come to fruition? So in other words, there's a downside for the tenant, there's risk, downside risk. Hey, we don't know what this lease looks like. Okay, but they took that risk, and your hypotheticals were, well, if we, you know, the reductio absurdum argument that if you he could have provided a lease that only allowed them to live in one room. Well, okay, well, on the corresponding downside to risk to the landlord is, you know what? The prospective tenants could say, well, this is unconscionable, or they could say, well, we don't have a lease yet. I mean, both sides took this risk, and they could walk, and he's left with a home that's unrented. So both parties took downside risk.
Where's the risk in here for him? There's nothing in here that says he even have to keep the property off the market. That was parole evidence. That was
Same not implied in an agreement.
lots of.
To enter into it with a lease if you gave him a deposit. Now, he might have to take it off MLF, but he can't obligate.
So where's the risk?
He can't obligate it to anybody else, right?
Well, where's the risk? I mean, he could have said, you know what, you haven't signed the lease yet, so I'm pulling it.
Well, but isn't that
And then he
your
gives-
opposite risk? You're saying, well.
The risk was he'd have to give them
It's favorable. And so in other words, I'm trying to trouble.
The risk for the landlord was if he decides that they're not worthy, which all he had to do is say, you know what, I've done the background check, you're not worthy, here's your money back. And then he leases it to somebody else. There's no risk to him at all. That's part of the liquidated damages thing. It's $34,000 in liquidated damages.
You have to take like a 30,000 foot view. We're gonna say that every time someone enters into a contract, say, hey, here's some money, I promise I'm gonna enter a lease or rent here. Okay, I promise to let you, pay me, enter into a lease and rent my place. That's unconscionable, or it's, it doesn't, it's not, there's not a parity. I mean,
It's an agreement.
this does not seem like an outlandish situation. This seems to correspond with typical human relations, which say, I've got a property, we're moving kind of fast, you gotta get in here, I gotta get this thing rented during the prime rental season. Here's the deal, you give me a deposit, I'm gonna say, if you're approved, you get to live here.
Mr. Vesely, can I ask you a question? A little more cabin. It seems to me that a lease has to be presented to the doctor and his wife. And there's a material issue of fact as to whether it was. Right?
That's correct.
So then the second question for me becomes whether or not the landlord presented a lease within a reasonable period of time. This document does not have any date, so I guess for commercial purposes, I would have to assume it has to be presented within a reasonable time. And it seems to me that then, when they pull the plug, there's another additional material fact as to whether or not a lease was provided to them in a reasonable period of time.
You're absolutely correct. The lease is a condition precedent. You have to present the lease. Even if the court says, okay, this is a contract, even though it lacks all these terms, it's still a contract. You have to present a proposed lease. But he never did.
The downside to the tenant is, let's ignore, you're living in one bedroom upstairs. But if he presents a lease with which the would-be tenants are not particularly enamored, or something they don't like, they bought that risk.
Yes.
Right? So he's
Yes,
getting
except if it's unconscionable, like you said,
Well,
it could be illusory, illusory contract happening, the guy presents a lease, it's like,
tenant,
a reasonable lease within reason, I think.
tenant
he's bought it.
below the line, and they don't want to go the line.
Yeah,
Maybe reasons better to argue, but they bought that risk.
I agree with you.
Okay.
I agree with you. And interestingly, in this case, there's some claim at some point that he actually presented a lease. But again, this is a disputed fact. There's lots of testimony saying he didn't, and then he said he did, but it didn't come in until 2 years into the case, and it was discovery, and that's not even part of the opponent's the case. They're arguing anticipatory repudiation, and as I've said, it's not necessarily anticipatory repudiation, but it's an argument that wasn't raised at the trial court level in the motion for summary judgment. That's the point. If they haven't raised it, there's a due process violation. My client did.
That's true on, because you're the appellant,
No, Your Honor, I'll give you the case.
and there's, we.
Here, this is the case. It's Green versus Peru.
For any alternative reason, as long as there's facts to support it.
I understand tipsy coachman, Your Honor, but this is not a tipsy coachman scenario. It's the fact that he didn't have due process in the lower court. And so you can't violate that by saying, let me just tell you what Green versus Green says. This is basically a paragraph and a half of an opinion. It's 349 Southern 3rd 543. And the sentence that matters is, we agree with the appellants that the trial court violated their due process rights and proper procedure by ruling on an issue that was not raised in the appellant's motion for partial summary judgment. So in that case, it's as if they ruled on, they weren't prepared. It wasn't part of the motion for summary judgment that anticipatory repudiation will be argued. It comes up at trial, and they say, well, we didn't get that memo that you were going to consider anticipatory repudiation. And the court says you can't do that. So how can this court step over the trial court? He never had a chance to argue that. And we believe that's a question of fact too, whether he pulled the plug or they pulled the plug. That's anticipatory repudiation on both ends, because he said he's never given them a lease. That was the facts. That's what would have come out in the motion for summary judgment had it been argued. So I don't think this court can step over the trial court and say, well, we're going to do it under the tipsy coachman doctrine because we believe the facts support anticipatory repudiation, that your guy pulled the plug prematurely. Of course, there's no time limit in this thing at all. It could have gone on for 10 years. you know, and he still would be in the hotel if he was trying to get into this house. He had to make a move at some point. His kids were they were sitting in a hotel going to school from a hotel. So at some point he had to make a move. So the court can't really, in my opinion, step over the trial court, and the trial court didn't even consider that. It's not anywhere in the transcript. It's not anywhere in the motion that he pulled the plug prematurely. So Your Honor, I really feel like by considering that,
It's not anywhere in there, I mean, you're characterizing that way, isn't it? Generally, the argument, advanced the trial on appeal by the company that, you know, you just said you weren't gonna sign the lease, what am I supposed to do? One day you said you're not gonna sign a lease, the next day you sign a lease somewhere else. I'm just, you know, playing devil's advocate, because that's what we're here for.
testimony
I
again,
mean, you're saying that your characterization of being completely blindsided on trial and on appeal, because of essentially, this may be strong and I'm creating, but what it sounds to me is the argument is, the procedural argument is, the appellant is completely blindsided because they use the term, you know, anticipatory repudiation. But isn't that just generally the gist of the argument, which is to say, on the 15th, the prospective tenant said, we're out of here.
they never argued that, Your Honor, not at the trial court level. They had it in there.
What is their argument? What was their argument at the trial level?
The argument is that they had a contract. That they gave them.
You said you're not gonna sign the lease. Isn't that the same thing? Isn't that very similar to saying anticipatory repudiation? Why don't we just dispense with that term and you address the issue, which could be very cogent arguments you have, and some have been described by my co-panelists here, which is why was the decision on August 15th not arbitrary? To just say, you know what, time's up, we're out of here, we're living in some other part of town.
Because if we had presented that case and the motion for summary judgment, if they had raised that case.
No, I'm asking you to address the argument. I'm not.
We would have presented the testimony that they didn't need to even say that, because he already said he was never going to present a lease to them. He already said that to them. That's in the evidence. That's in the testimony from the depositions. This is the motion for summary judgment. That should be determined at trial. And the fact of the matter is that that's a fact issue as well, whether they did or did not pull the plug on this, and whether the plug was already pulled. Those things need to be dealt with at trial. This is not something that should be determined on a motion for summary judgment. All of these inferences that you're making, Judge, go to our favor.
Mr.
We
Bell,
should have those inferences.
I'm sorry to interrupt, but I know you wanted to say some time for rebuttal.
Yeah.
So you're.
Well, Your Honor, I just,
Do that, wrap up.
you know, this is de novo review, Your Honor. It's de novo review, and, you know, those inferences, they go to us. If there's a reasonable dispute in the facts, it goes to the appellant. Your Honor, and, you know, even under the new rule, which I think Judge Battles, he's a great judge, but I think this is such a new thing, this new rule that they're trying to apply. I think he lost sight of the fact that if there's a material issue and fact of dispute, that we need to send it to the trial. And that's where this belongs, Your Honors. So, and the ultimate question that this court must ask itself, and this comes from the case law that cites the federal rule, that all the federal case law is could a reasonable juror conclude that return a verdict for the non-moving party? And then because we have this testimony that he pulled the plug, that, you know, that we didn't pull the plug, he pulled the plug, that he was never going to present a release, that the jury could find for my client. And for that reason, Your Honor, we're asking the court to please reverse this and let us have our day in court. Thank you.
Got a couple of minutes left.
May it please the court, Donald Mahakovich from Adams and Reese. I represent the appellee Robert Wagner. The keys for review here are two things. One being the 2-page lease agreement, lease application, which I know everybody here has already reviewed, and a very brief 6-day timeline, which it sounds like all three of you are already very familiar with. But let me highlight a few things.
So what did he say he wasn't gonna give him a lease?
That's not the testimony, Your Honor. The testimony was that at the time that Mrs. Moore came to see the property after Mr. Moore had already seen it 3 days prior, there was not yet a lease prepared, and he went to hand her the keys and said, you don't need a lease to take
I
possession.
thought I saw ordered that said, I don't need to give you a lease, and that was the testimony, it's summary judgment evidence, right?
There
There
were
was testimony that he said, I don't need one, I don't need to give you one.
I recall reading some hearsay testimony where the doctor said that when at a meeting that he wasn't at between his wife and my client, Robert Wagner, that Robert Wagner allegedly said that, but he wasn't there. So I don't think that's
What's the fact issue? What's the fact issue of whether he provided a lease within a reasonable amount of time?
Because of the timeline, they repudiated it. It starts out, you can look at appellant's own brief.
Wait a minute, but if your client was obligated by this agreement to provide a lease within a reasonable time, okay, and they don't, it's repudiation isn't an issue. So why isn't there a fact question about whether or not that your client provided a lease within a reasonable amount of time?
Because of a combination of what appellants already admitted to in their brief in conjunction with the timeline. The appellants admit, this is on page 38 of their initial brief, quote, they expected to be presented with a proposed lease within a matter of days of submitting the lease application.
Right.
Yet, as you're familiar with the timeline, within a matter of just 6 days after signing the lease application, they refused to lease the property because they already identified another property and leased it.
But at the time somebody backs out, do they even know what the monthly rent is going to be?
Yes, that is also admitted to an appellant's brief. But I don't recall the exact amount, but
700 something.
7,000 something. Yes. Yes, if you look at the deposit amount, it's basically $20,000 that would be applied as a security deposit, and then the remainder 14,000 something divided by 2 is the monthly rent. But that's also admitted to an appellant's brief. They admit to agreement on all the essential terms, the parties to the contract, the identification of the property, the monthly lease amount, the duration, which is 12 months, the start date of ASAP, and the liquidated damages.
Well, 6 days later, they did this or that, and that doesn't really answer the question, because maybe under the circumstances of this case, that was unreasonable. Maybe they needed, as soon as there was this agreement, this was fine, give them the lease.
Well, they say in their
And it
brief,
was unreasonable to withhold the written lease.
they say in their
For 3
brief,
days, or 4 days, or 5 days, and isn't that a jury question? Isn't that a fact question?
not when they already admit in their brief that they expected it within a number of days, and then.
Okay, but why don't we get that specific? So when was the communication, when was it communicated that they had been approved? What day?
That I don't know. I don't think that
So,
appears in the
okay.
record anywhere. It's clear that they were approved.
Okay, so, but when was the lease application, whatever it's called, the first agreement?
Right.
Lease application entered into?
That was on August 6th.
August 6th, and on the 15th, I'm not gonna put labels on it, repudiation, pulling the plug, because there's a, competing for employment.
The 12th.
They said on the 12th.
The 12th, not the 15th. The 12th is when he sent the text saying that they would not rent the Cheval property, and they demanded the return of the
It
deposit.
was not corrected by the appellant. Okay, so not the 15th, the 16th is when they entered into the other lease. Is that right?
That is what they say in their brief, but that's that other lease. is
6
not
days,
correct.
and then you're not even sure that the record reflects when first it's got to be approval, right? I mean, well, I guess you could have given them the lease before the approval to peruse, right? But at some point after the approval, which is another condition precedent, right? For retention of, or the obligation entered in the lease, right? that their obligation under the lease doesn't arise until it's approved. And then so that between the approval and the presentation of the lease, I mean, what would be reasonable?
Well, the approval, I don't.
How long could the landlord wait from the announcement of the approval? Meaning which would give rise to their obligation to enter into a lease and the presentation of the lease. For the, how long could he reasonably wait to do that?
Well, I know that the approval, like, again, I don't know the exact date, but I know that the application was signed on the 6th and the approval was given before the 9th, because that's when he attempted to give her the keys and she backed away and didn't want to take it till he actually presented her with the
All
lease.
he has, he's carrying around the key. He wants to leave, it's like a little property and shut it out. He doesn't even have a form. I mean, that just strikes me as, we gotta resolve this before the jury. He doesn't even have a form to give them. And there's conflicting evidence as to whether or not he ever intended to give them a form.
Well, I don't think there's conflicting evidence as to the timeline, that just 6 days after signing the lease application, they had already identified another property.
Well, how long do they have to wait? It's been approved. He's trying to give them a key. He's trying to give them a key. Why didn't he give them a lease?
Could we infer?
How long does they have to wait? Oh, no,
Well, I
another
think-
couple months. We'll get around to it. We'll give you the lease then. Don't worry about it.
Well, this wasn't a couple of months, this was just some.
But you're saying 6 days, like that's some magic number. How long?
Well, it was
If he could give them a
six,
key, couldn't he give them a lease?
well, again, it was just 6 calendar days, not 6 business days.
We don't have an agreement in which we have to worry about whether time is of the essence and try to define whether there was an urgency, because it said ASAP.
It said that they wanted occupancy ASAP, and he offered that to them ASAP. He offered them the keys.
Right, but he didn't give them a lease.
Well, not within those 6 days before they
The
refused.
key, they move in and he's like, oh, you know, they're there a month. It's like, okay, you gotta move out. And they don't have a lease. They're there month to month.
I mean, I think the reality you can see from the timeline of what's going on here is Dr. Moore came to Tampa, he looked at it, he signed the lease application. His wife came down 3 days later, and she looked at it, she didn't take the keys because she already had appointments. These are established in the texts that are,
Well,
in the record.
you know, I think one could ask, why would she take the key when there's no lease? I mean, I think all this that you're arguing, you're laying out here, although if you really look at it, she came to town and what really happened. That's why this isn't capable of resolution on a motion for summary judgment. There's different ways that one could view these facts. I mean, your view is these people never intended to lease this property. They were already, the wife didn't like it, she's looking at other properties, they were never gonna do it. Their view is you were never gonna give them a lease, you had this nice fat $34,000 deposit for taking an application, and you're never gonna give them a lease. Or you're gonna let them move in and then give them a lease that maybe just has unfavorable terms. I mean, you're never gonna give them a lease, you're saying, why do you need a lease? So, I mean, there's different, you're characterizing the facts one way. The appellant has another characterization. Why is this a summary judgment?
because of the 6-day timeline, to which there are no genuine issues of material fact. It says Dr. Moore came to Tampa, he signed a lease application. The next day, his wife exchanged texts with the real estate agent, lined up a number of other properties that she wanted to look at. On the 9th, she came and looked at the property. Mr. Wagner offered her the keys, she refused. The next couple of days, she looked at other properties. And according to Dr. Moore's testimony, here's his quote: after my wife viewed the property on Renwick Circle, that's the Tampa Homes property, she was provided with a lease immediately within 3 hours of viewing the property, and she signed that lease. You pair that together.
They gave them the lease in 3 hours.
And that was that, they already said on the 12th, you know, we're not gonna lease, so we can't do it.
No, that was before.
No, the Tampa Palm situation happened after the 12th, right?
No, sir. No, sir. If you pair the text, which are in the record at 12:26 to 12:32, that establishes when she was going to see these various properties. She went to see Tampa Palm.
And we don't know the date of when it was communicated that their lease application was approved, did we? Didn't you say you didn't know that date or it wasn't? in-
I said that it was between the 6th and the 9th. I don't know which of those dates. I don't know the exact date, but between
We
the,
can infer, we can imagine the jury can infer that at the time he handed the keys over, he approved them.
correct. Correct. Yeah, that had already been approved.
So let's look at the causes of action. So under the new standard, I'm not gonna, I'm not in front of me, but, there's been talk about the new standard, could a jury, could we, on a number review, imagine a jury entering judgment in favor of the appellants on conversion, negligent misrepresentation, unjust enrichment, well, you have my $4,000. And, the equities suggest the height you give it back. Breach of oral contract, walk through why every single one of those, we can't envision a jury entering a verdict in favor of the non-moving party.
One is because the only cause of action as to which there are any arguments in appellant's initial brief is count 6, the declaratory judgment action. They expressly abandoned count 5, which was for a return of a deposit under the Florida landlord tenant statute. As to the other 4 causes of action you're referring to, conversion would be, again, this isn't argued in the brief anywhere, so I'm responding to an argument that's never been made. They don't appeal that, but first thing that comes to mind for that and negligent misrepresentation is the independent tort doctrine. And for unjust enrichment, it would be the simple argument that when there's a written contract, you can't recover for unjust enrichment. But again, these are not raised in appellant's briefs. I'm responding to arguments that were never made. There are no arguments whatsoever made as to those counts.
What about the declaratory judgment?
That's what we've been talking about here. That's the only one that's the subject of this appeal. Plaintiffs wanted a declaration that there was no contract. And I think everybody here recognizes that there was in fact a contract. Judge Battles correctly ruled that there was a contract because there was an offer by the defendant. There was an acceptance by Dr. Moore. There was mutual consideration and that the plaintiffs paid the deposit and the defendants held the property. The terms were simple. If the application is not approved, the deposit would be returned. If the application was approved and the applicant refused to enter into a lease, the deposit would be forfeited as liquidated damages. And that's what happened here. Within 6 days of signing the lease application, they had already identified a Tampa Palms property. Mrs. Moore signed the lease to it. Dr. Moore came down and co-signed it a couple of days after that. They repudiated this contract within a few days after signing it. Any further questions? Thank you.
At the outset, it wouldn't be the first time I was wrong about something, but I want to make sure, whether I am or not, that you essentially abandoned.
No. The only one we abandoned was 5.
Conversion, unjust enrichment.
No, the only one we abandoned was 5. And the reason why we argued what we argued is because Judge Battles looked at count 4 first and made the determination that this was a binding contract and that they should be held feet to the fire. So
Let's presume that it was, let's take a discussion and talk about the other. Well, I guess if it's binding contract, we can't unjust enrichment, but never mind, you go on. If you're arguing, I just want to make sure.
thank you.
What said about it, essentially.
Again, this is the repudiation argument I was telling you that what they make in their answer brief, and it's something that should not have been raised because it wasn't raised before the trial court, the motion for summary judgment. If you want to send this back down for a new motion for summary judgment, they'll have the right to do that. They can raise it to this repudiation. We'll raise the same thing, and we'll have a decision on that. But again, that's a fact issue that needs to be determined by a jury. Okay. Secondly, you're right. One of the things that this contract talks about is the deposit return. Your Honor, you pointed out that 14,000 plus of the deposit that the court awarded to them was for rent. It's not even, if you look at the contract, this agreement here, if you will, it's 20,000 of it was the deposit. So why is he holding all of our money? So, there's so many things wrong with this case, Your Honor, that it needs to go back for a jury trial. Now, let the jury determine whether or not these things played out the way that they say it did, the way we say it did. And Your Honor, again, two points of clarification. It wasn't just my client that said that Mr. Wagner said he wasn't ever going to present a lease. It was also Ms. Pitcher, and that's on page 1 of my reply brief.
That's the agent.
The agent, yes, she said, page 1269 of the record, each time I asked about the lease, Mr. Wagner said that he did not need a lease and was entitled to keep the deposit. So there's ample evidence that he had no intentions of ever giving them a lease. And secondly, Your Honor, this issue about when she signed the lease for the new place, I tried to move to supplement the record, so I can't get into what that was exactly, but the evidence that they point to suggest that she signed a lease on the 12th is completely contrary.
Can I ask some, just clarify, I might have stated something, as I said when the first time I was wrong. But I think what I might have conflated two different anecdotes. One is the signing of the tampon lease. The other is the evidence that she was presented with a lease, immediately upon, looking at the home in Tampa Palm. Is there any dispute about when that happened? Was that on the 12th?
Renwick Circle property that she looked at on the 16th.
You're saying she didn't look at it until the 16th? Or is it?
There's no-
For Appellee, you just said that.
The actual, there's no
She was presented with a
reference to
lease.
which house it was, but the Renwick Circle house the contract was signed later, okay? And the fact of the matter is, my client testified under deposition that he had a lease presented to him on the 15th, he would have signed the lease for the Wagner house on the 15th. That's his testimony. That's in my brief. He would have signed it on the 15th. So yes, he did say on the 12th, I'm fed up. I can't do this anymore. We're not going to go forward. But he testified he would have signed it on the 15th. It wasn't until the 16th that they signed the other property.
Okay, Mr. Vesely, you're at the conclusion.
Thank you, Your Honors. I really do appreciate your time.
Okay, thank you, Brad.
Thank you.
All right, next we've got, CTC Harbor Island, both this manor at Harbor Island.
Morning, Your Honors. May it please the court, counsel, Andrew Geekus. On behalf of the appellants, I'm joined with my brother, John Anthony, as well